The CEO tried to close a $100 million deal, and then the screen went red. I was standing 3 seats down from her, close enough to smell the burnt coffee from the conference machine. Toronto was on the video wall. Lawyers everywhere. Everyone smiling like it was already done. Then the buyer's counsel stopped mid-sentence. Status change on core asset. He said, "We need clarification. Victoria Hale didn't understand at first." I did. 3 days earlier. She had laughed when I warned her about the loophole. Someone at your level focuses on the deal. Someone at mine focuses on what happens when the deal breaks. I nodded. That night, I bought the rights for $1. But let me back up. My name is Althea Merrick. I've worked in compliance in Chicago for 20 years. The kind of job nobody brags about at dinner parties. I read contracts. I look for things other people step over. We were acquiring a regional logistics company tied into the Great Lakes Freight Corridor. Big deal. Strategic routes. Expansion into cross-border shipping. Victoria loved calling it transformational. 6 months earlier, she cut our internal legal audit budget, said we were over-lawyering. I remember that phrase. I remember the CFO nodding like it was clever. 3 days before closing, I ran a continuity check on the core routing algorithm. Habit. The filing that keeps the intellectual property active during transfer hadn't been finalized. It wasn't dramatic. Just a missing confirmation in the Federal Registry. I went to Victoria privately first. She invited the CFO and outside counsel, and halfway through, that's when it turned into theater. "We are not pausing a $100 million transaction over a clerical technicality," she said. Then she added, smiling. "And frankly, someone at your level wouldn't understand cross-border structuring. You ever feel a room shift like that? It gets quiet." But not respectful. I didn't argue. I asked for written confirmation that we were proceeding without renewal. She gave it. At 11:48 that night, I sent a recap email and copied external counsel. Then I reopened the original continuity agreement from 2012. That's when I found the clause nobody remembered anymore. I pulled the 2012 continuity agreement from archive storage like I was digging up something I wasn't supposed to touch. Back then, the company almost folded. Banks circling, vendors unpaid. The board panicked and built in safeguards around the core routing algorithm. I remember because I was the junior compliance analyst stuck reviewing footnotes while everyone else ran damage control. Buried in Section 9 was the line nobody talks about anymore. Section 9 of the 2012 bylaws wasn't a suggestion. It was a statutory mandate. As the registered custodian, I held a fiduciary duty to the asset itself, independent of the CEO's directives. The $1 activation wasn't a loophole. It was a legal kill switch designed to protect shareholders from administrative negligence. In the eyes of the Federal Registry, I wasn't just an employee, I was the legal gatekeeper of that code. Althea Merrick. Authorized custodian. I just stared at it for a minute. This wasn't a clerical fluke. It was a statutory mandate. Section 9 of the 2012 bylaws was a legal kill switch designed to protect the company's core assets from administrative negligence. As the registered custodian, I held a fiduciary duty to the asset itself, independent of Victoria's directives. In the eyes of the Federal Registry, I wasn't just an employee, I was the legal gatekeeper of that code. I called my attorney, Graham Adler. I've worked with him on boring audit disputes. Nothing like this. If I activate it, am I stealing? I asked. You're not stealing, he replied. You're triggering a compliance safeguard. And my job, they'll argue breach of fiduciary duty. They'll say you acted against corporate interest. I didn't. They'll still say it. That sat heavy. Then I opened an internal memo I probably wasn't meant to see. Victoria's restructuring plan post-acquisition. Phase 2, spin off the routing algorithm into a separate holding entity. Phase 3, workforce optimization. 200 engineering roles flagged for reduction. I called Graham back. They're planning to strip the asset. I told him. He paused. If that's true, activating the hold isn't sabotage. It's preservation. Preservation. That word hit different. I wasn't trying to embarrass Victoria. I wasn't trying to win an argument. I was looking at a company about to transfer its most valuable asset without finishing the paperwork and then possibly gut the people who built it. I swear. I almost closed the file and let it go. Almost. Then I opened the federal portal login screen. It was 4 in the morning when I logged into the federal registry portal. The lake was black outside my apartment window. Wind pushing against the glass, my laptop humming like it knew this wasn't routine. I had the filing form open. Protective temporary hold. Registered custodian activation. $1. My finger hovered over the submit button longer than I want to admit. I called Graham again. It wasn't for legal advice. It was for the anchor of another human voice before I crossed the line. If the buyer walks, he told me. Voice rough with sleep. They'll blame you. Publicly or not. It won't matter. This industry is small. I'm not trying to tank the deal. I know, but intent won't protect you. I notified the board within 12 hours of activating. That matters. It helps. Doesn't guarantee anything. Silence. I could hear him breathing. Althea, he added. Once you press submit, there's no half step. I stared at the confirmation box. It asked if I understood that activation may delay transfer of ownership. Delay, not cancel. I understand, I muttered. I clicked. Payment processed. $1 plus administrative fee. Receipt generated. Status updated to conditional hold pending rectification. For a second, I just sat there. I drafted a formal notice to the board audit committee. No emotion. Just timeline. Documentation. Registry confirmation. Sent it before dawn. I did not CC Victoria. By 8:30, I was in the office like always. Same desk, same badge, same coffee that tastes like burnt cardboard. Nobody looked at me differently. Nobody knew. I opened my inbox and waited. It would not take long for someone to see the change. The call came just after 10. Conference room. Full legal team. Toronto on the screen. I stood against the wall, not invited to speak. The buyer's lead counsel, Daniel Cho, adjusted his glasses and cleared his throat. We're seeing a status change on the core routing algorithm, he began. Conditional. Pending rectification. Victoria leaned back like she was bored. That's a clerical lag, she replied. We'll confirm. Daniel didn't blink. Our compliance team ran a sweep at 9:12 this morning. The registry reflects an active protective temporary hold. The room shifted. Chairs creaked. Someone stopped typing. Victoria turned to our outside counsel. Fix it. Counsel pulled up the federal portal. Typed fast. Frowned. It's rejecting renewal. Why there's an active hold attached. Daniel's voice cut through the speaker. Without resolution within 24 hours. We paused closing. Victoria's jaw tightened. You're threatening to walk, I'm stating governance protocol. We cannot transfer ownership of an asset under conditional restriction. And if we don't resolve in 24 hours, we suspend, issue notice to investors, and reopen valuation. That meant renegotiation. That meant blood. Victoria leaned toward the screen. We'll correct the filing. Daniel nodded once. Then please do. The call ended. Our counsel refreshed the registry page. There it was, in black text. Activating custodian Althea Merrick. The silence in that room felt heavy enough to bruise. Victoria didn't yell, didn't slam anything. She just read my name twice. This wasn't a glitch. She murmured. Outside counsel shifted uneasily. The hold is legally valid. Victoria looked at him. Then at the screen again. She notified the board, she asked quietly. I believe so. Victoria exhaled through her nose. Slow, controlled. Get her in my office, she said. Not loud, not dramatic. Just precise. I was still standing in the room when she turned around and met my eyes. She already knew. Victoria's office door shut softly behind me. No drama, no witnesses. She stayed standing. I stayed seated. Corporate counsel. Mark Feldman sat to her right with a legal pad already open. Victoria folded her arms. You triggered the hold? Yes. You understood that action could destabilize a $100 million transaction? I understood the filing was incomplete. Mark cleared his throat. As an employee, you owe fiduciary duty to the corporation. I notified the audit committee within 12 hours. That doesn't erase conflict of interest. It addresses concealment. Victoria stepped closer to the desk. Calm, controlled, almost clinical. You could have escalated internally. I did. You escalated after you acted. I escalated before closing. Mark leaned forward. The buyer is threatening price renegotiation. I'm aware. Victoria studied me like she was recalculating. I'll make this simple. She said, release the hold. Today, I'll authorize a retention payment. $100,000? Quietly? For a second, I almost laughed. Not because it was funny, because it was clean. Easy. If I wanted leverage, I told her. I would have waited until the deal closed. Her eyes sharpened. So this is principle, it's governance. Mark tapped his pen. If the board views your action as harmful, you could face termination and potential civil liability. I have written confirmation that you chose not to renew. I replied, I have email recap, registry timestamp, board notice. I slid the folder across the desk. Victoria didn't look at it immediately. You embarrassed this company, she said quietly. I preserved a material asset. The silence stretched. Then she nodded once. Effective immediately. You're suspended pending review. Mark closed his folder. Victoria walked around the desk and opened the door. You should speak to your lawyer, she added. I stood up. My badge still worked. For now. The turnstile didn't budge. The screen flashed void, and the security guard's sudden interest in his shoes told me the order had come from the top. The guard avoided eye contact. I've been told to direct you to HR. HR didn't look angry. Just rehearsed. You're placed on administrative leave pending review, the director told me. Access is suspended effective immediately. My email deactivated. My files secured. That word again. By noon, my phone was buzzing. Chicago's corporate legal circle is tight. People talk. Graham called first. They're framing this as destabilization. He said, buyer issued a 72-hour ultimatum. I saw the notice. They're threatening a $15 million price reduction. I know. And if that fails, they walk. I pressed my fingers against my forehead. If they walk, Graham continued, public narrative will point at you. I acted legally. Legal doesn't mean immune. He paused. My retainer just doubled. This isn't routine compliance. I'll wire it. There went a chunk of savings I'd been pretending was untouchable. That afternoon, my daughter called from Madison. Mom, are you in trouble? She asked. No, hello. Define trouble. Someone sent me a link. Company stock dipped. Your name's in some internal memo. I'm handling it. Did you do something illegal? Silence on the line? Then why does it feel like you're lying? I'm not lying. I'm in the middle of it. After we hung up, I opened my laptop. The buyer had formally reiterated resolve governance issue or withdraw. Stock down 4%. 4% is not catastrophic, but it's loud. I drafted a letter to the board releasing the hold. It took 3 paragraphs to undo everything. I stared at it for a long time. Graham texted, if you fold now, they win the narrative. I closed the draft without sending. For the first time since clicking submit at 4 in the morning, I felt unsure. Not about the clause, about the cost. I didn't write a letter of defense. I wrote a restructuring mandate. By noon, the board of directors had received an encrypted PDF. I didn't use corporate email. I used a private server, ensuring the record existed outside of Victoria's reach. To the board audit committee, the protective temporary hold currently active on the core routing algorithm is a legal safeguard, triggered to prevent the transfer of an unverified asset. I will release this hold immediately upon the execution of a binding governance addendum containing the following terms. 1. Workforce stabilization. A 24-month employment guarantee for the engineering corps. This asset is the people, not just the code. 2. Structural integrity. A permanent injunction against stripping or spinning off the algorithm into sub-holding entities for a period of 5 years. 3. Governance reform. The immediate reinstatement of the Independent Risk Oversight Committee with a direct reporting line to the board, bypassing the office of the CEO. I am not seeking a settlement. I am not seeking a retention bonus. I am seeking compliance. The response didn't come via email. It came through Richard Calloway, the longest-serving member of the board. He called me while I was sitting on a park bench by the lake, the wind biting at my coat. Althea. He started, his voice like dry parchment. You've paralyzed a $100 million closing. Do you realize the liability you've invited? I haven't paralyzed the deal. Richard, I've secured it. Victoria was about to sell the buyer an empty shell. When they found out post-closing, the lawsuits would have ended this company. Silence. Richard wasn't a fool. He knew the strip and flip strategy Victoria was planning. The buyer is spooked. He countered. They want a clean title by tomorrow, or they're cutting the valuation by 15%. Then give them a clean title. I said evenly. Sign the addendum. Show them that this company has adult supervision. If you sign, I release the hold in 60 seconds. If you don't, the hold stays until the Federal Registry conducts a full forensic audit. That takes 6 months. You don't have 6 months. I heard him exhale a long, weary sound. He wasn't arguing with my law. He was weighing the cost of Victoria's ego against the company's survival. You're playing a dangerous game. Althea, you'll never have a friend in this C-suite again. I don't need friends in the C-suite. Richard, I need a company that follows its own bylaws. We convene the emergency session at 5, he said, and hung up. I stayed by the water. For the first time, the weight didn't feel like a burden. It felt like leverage. The meeting was held at a law firm downtown. Neutral ground, long table, too much bottled water. Nobody smiling. Victoria sat across from me. Same posture she uses in investor calls. Controlled, measured. Independent counsel opened a binder. Let's walk through the timeline. He began. He started with the legal audit reduction 6 months earlier. Budget cuts eliminated internal IP continuity review. Victoria leaned forward. We streamlined redundancy. External counsel was retained. Counsel flipped a page. External counsel was not assigned to continuity verification. Silence. Next item. 2 compliance memoranda regarding asset transfer risk were acknowledged but not escalated. Victoria's jaw tightened. Those memos were advisory, not mandatory. They identified material exposure. They identified hypothetical exposure. Then the missed filing. The continuity filing was incomplete at the time of transfer preparation. Counsel continued. Victoria looked at me. That was an administrative lapse. It became a structural lapse. He replied evenly. The buyer's counsel joined by video. Our position remains unchanged. Daniel said, without governance remediation, we cannot proceed. Victoria exhaled slowly. You're using this as leverage. We're using it as protection. The room felt smaller. Then counsel addressed my action. Ms. United, Merrick activated the protective temporary hold at 4 a.m, notified the board within 12 hours, and preserved transfer eligibility. Victoria turned to me. You destabilized a $100 million transaction. I preserved a $100 million asset. One board member, Richard Calloway, leaned back. Althea, why not escalate before activating? I escalated 3 days earlier. I received written confirmation that renewal would not occur. Counsel slid copies across the table. Victoria didn't touch them. She acted unilaterally. Victoria said, I acted under a safeguard created after near bankruptcy. I replied, registered custodian authority. Documented. Counsel continued. Audit further reveals 2 prior compliance warnings dismissed without board review. Victoria's head lifted. We cannot paralyze growth because risk officers fear exposure. Richard answered her this time. We cannot grow by ignoring exposure. Silence again. Heavy. Victoria tried once more. Investor pressure required margin expansion. Timing mattered. And governance matters more, Richard said quietly. Then they turned to me. I didn't have a speech prepared. I used a $1 federal safeguard to fulfill a duty that this board's budget cuts failed to protect. No one interrupted. The vote wasn't loud, just raised hands. Victoria was placed on administrative leave pending governance investigation. No shouting, no dramatic exit. She gathered her folder slowly, stood up, and walked out without looking at me. The buyer's counsel waited on screen. We'll await revised governance structure, Daniel said. The meeting adjourned. The deal wasn't saved yet, but it wasn't dead either. The revised governance package landed in my inbox at 9:14 in the morning. Independent Risk Oversight Committee reinstated. Reporting lines separate from the Chief Executive Officer. External governance audit within 6 months. 200 engineers guaranteed employment for 24 months. No algorithm separation without full board approval. Richard called 10 minutes later. These are binding amendments. He told me, effective immediately. And Victoria, I asked, she's out pending investigation. That wasn't triumph. It sounded like cleanup. Will the buyer accept? I pressed. We've shared the draft. A pause. They've indicated conditional approval. Conditional? That word again. By noon, Daniel from Toronto joined a follow-up call. Our board reviewed the remediation plan. He began. The buyer realized that without the 200 engineers and the algorithm's integrity, they were buying a dead asset. My conditions didn't hurt the deal. They guaranteed the ROI. They dropped the price cut demand the moment the board signed the addendum. It will be, I answered. You understand this delay costs both sides credibility. I understand. I said, that's why it won't happen again. He studied me through the screen. We prefer stability. He added, so do I. After the call, I logged into the Federal Registry. Protective temporary hold active. I entered the release code. Confirmation box appeared. Releasing would restore full transfer eligibility. I clicked. Payment reference $1. Status updated to cleared. I forwarded confirmation to the board and external counsel. Richard responded first. Thank you. Althea. That was it. No ceremony. Later that afternoon, the buyer issued a formal notice transaction proceeding as scheduled. Stock stabilized? The engineers didn't know the details. They just knew layoffs weren't happening next quarter. I went home exhausted, not proud, not vindicated, just aware that a $1 filing had nearly cost me everything and somehow kept the company intact. The deal was alive. So was the risk. Closing day felt quieter than I expected. No celebration banners, no champagne, just lawyers, laptops, and a lot of controlled breathing. I sat at the table as a risk signatory. Not in the back, not taking notes. Daniel looked at me through the screen. Risk confirmation, he asked. Governance reforms executed. Independent oversight active. No outstanding continuity issues. I replied, confirmed. He nodded once. Then we proceed. Victoria wasn't there. Official statement later called it personal reasons. That's how corporations bury things without digging. After signatures. Richard pulled me aside. We'd like you to step in as Chief Risk and Contract Strategy Officer. He said, reporting directly to the board, only if independence is written into the charter. I told him, it already is. That hit harder than applause. Later that evening, I sat alone at my desk. Same office, different gravity. Here's what I learned, honestly. Power isn't the title on the door, it's the signature on the compliance filing that no one dared to read until it was too late. Integrity doesn't win fast, it survives long. And if you ever feel small in a room, read the fine print. That's where the real authority hides. I wasn't brave every minute. I almost folded. I almost chose comfort over consequence. But $1 forced a conversation no one wanted to have. They thought I was just a compliance officer. They forgot that the person who reads the map is the one who decides where the ship can go. She thought I didn't understand the law. I just understood it well enough to stop her.